Good afternoon, everyone. In Introduction to Law, we're on Chapter 16, the final chapter in the text, and it's about criminal procedure and really about constitutional law. I almost wish they bifurcated it and put it in two different chapters. Um, but nonetheless, it's together, and maybe in some ways it does make sense to see the application of some of these constitutional principles and how they've evolved historically to be applicable, especially in the criminal realm. The chapter starts off with the concept of the approach of the Supreme Court in the 14th Amendment's Due Process Clause and Equal Protection Clause. What that has done, the 14th Amendment has made the bulk of the Bill of Rights, including those related to criminal procedure, applicable to the states. As some of you know, you've taken History of the Constitution with me, or maybe just know through civic learning, that the Bill of Rights were designed to be a prophylactic against federal overreach. It wasn't meant to be applicable to the state. In fact, the First Amendment, for example, says Congress shall pass no law, meaning it's regarding a federal limitation. But over time, the 14th Amendment has been used as a conduit to make many of the fundamental principles in the Bill of Rights become applicable to state action as well. And that's largely been done through the Due Process Clause in basically the statement in the 14th Amendment that no state shall deprive its citizens of due process or equal protection of the law. And what many of the justices have interpreted over time was that equal protection of the law and due process means those fundamental inherent rights that we often identify in the Bill of Rights. And so it's not been entirely made applicable to the states, but the fundamentals have. The one that hasn't, that's big with related to criminal procedure and criminal law, is the grand jury process. So I'll just start with what a grand jury is. In almost every state, and definitely in the federal government, because the federal government mandates it in the Fifth Amendment, that no felony charges can be brought unless through the grand jury process. And what is a grand jury? There's two kinds of juries. One's a grand, the other's a petite. A petite jury actually hears a trial. That way, those kinds of things we watch on television, where facts are introduced and arguments are made about what's to be believed factually, and testimony is made, and then the jury comes to a conclusion. That's a petite jury that comes to a verdict of guilt or not guilt in a criminal session. And civil would be liable or not liable, or responsible or not responsible, depending on how the state has their system set up. But criminal, it's guilty or not guilty for a petite jury. So what's a grand jury? Grand and petite. Grand jury is an investigative body. And in Massachusetts, for example, we use Massachusetts as kind of the way in which we'll work off of as a model, if you will. Grand juries sit in the different counties. 23 people in number sit on a grand jury. I think right now Massachusetts does 30 days. It's changed over time. There was a time where a grand jury would sit for 90 days. A pretty long time to be in a jury. But they sit and they're supposed to be a secret body, and only the government is aware of their existence, and only the government, the prosecutors, present evidence to the grand jury. And those 23 jurors hear sort of a preliminary thrust of evidence from a one-sided perspective, from the government's perspective. And all the grand jury is supposed to do is to determine whether or not the government has enough evidence as a threshold matter to suggest that there's probable cause, that it's a probability that the allegations as made have validity, and therefore the case can go forward. And that's called an indictment. And so when 23 jurors hear it, 12, just a simple majority, have to believe there's probable cause for the elements of the claim to have been established. Not that the defendant's guilty, not that there's mitigating circumstances, not that there's a potentially good defense to be raised. It's just that on the threshold application of a criminal complaint, the government's submitted enough evidence before the grand jury to show that the elements have been satisfied for purposes of that very low threshold called probable cause. Most of the time when a grand jury presentment occurs, the vast majority of cases do come out with an indictment. If there's no indictment, it's called a null bill. It works very similar in the federal level. All federal criminal cases, I should say, have to go through the grand jury system. Not true in all states. Some states don't have a grand jury trial system, and some have, like Massachusetts, a two-tiered system. One is felony cases can go through the grand jury system, most do, and they are presented there. And if the grand jury believes there's enough evidence to establish probable cause, the charge is made. Now the defendant will be brought in for an arraignment in the Superior Court. However, there is a second avenue in which we can have defendants charged with felonies in Massachusetts state court system. That's called a bind-over felony hearing or a probable cause hearing. It's done in the district court. It's almost kind of like a mini trial just to determine whether there's probable cause. Big difference, though. It's open to the public. The defendant's aware of it. The defendant can present evidence and challenge a case. It's almost a mini trial to kind of weed out very weak cases. And it's called a bind-over felony hearing or a probable cause hearing. The vast majority of cases don't go that avenue, but sometimes they do. And some states don't have it at all. That's all they do is do these kind of bind over proceedings before a preliminary judge or a district court judge or something like that, just to make sure there's sufficient evidence to go forward to an arraignment. But the Fifth Amendment provides that a grand jury shall be hearing of all federal criminal cases. But that's incorporation. So through incorporation, sometimes they haven't taken up that part of the Fifth Amendment to make it applicable to all the states. Other amendments have been. The First Amendment in its entirety has been made applicable to the states. That's not a criminal procedural amendment. The Second Amendment, guns have really in modern times have been finally made applicable to have state governing authority to have to basically follow the mandates of the Second Amendment. Third Amendment is not as pertinent. That's quartering of soldiers in people's private homes and private property. It's not an issue. But the Fourth Amendment's a huge one, and that's one that in the 1960s became incorporated through a famous case called Mapp v. Ohio. Dolly Mapp was her name, and her house was searched without a valid warrant, and everybody acknowledged they didn't have probable cause, so therefore it was a violation of the Fourth Amendment, a right from searches and seizures. And it was a case called Weeks back in the 19-teens. I can't give you the specific, I think it was 1918, 1919. And they established something called the exclusionary rule, that if evidence was seized illegally by impermissible police conduct, meaning they violated the Fourth Amendment, the evidence had to be excluded, suppressed. Well, that was only true in the federal court. And so state law enforcement could violate the Fourth Amendment all day long, and there wasn't a repercussion for having the evidence suppressed because the Fourth Amendment didn't apply to state action. That surprises a lot of people. But in the 1960s, they started recognizing that it was creating a really, really unjust system, that the fundamental right to be free from unreasonable searches and seizures didn't extend to state or local law enforcement. And it's huge because over 95% of all criminal cases are actually state or local. They're not federal. Federal are very, very big cases that often involve activities that go across state lines and things of that nature or have national significance. Most criminal behavior is state. So the process of incorporation, what is it? The 14th Amendment has made most of the criminal procedure applications found in the Bill of Rights to be applicable to states and local communities. And that's through the due process clause. And it's called selective incorporation. They started off with the Fifth Amendment, the right to be free from self-incrimination, double jeopardy. And then the Sixth Amendment, the right to have counsel. That's the famous Gideon case in the 1960s, where Gideon was charged in the state of Florida. Some of you have had me in live classes, for example, traditional brick and mortar classes. And I show this very good film from Sunnyvale, the Constitutional Law Center. And they talk about the Gideon case in the 1960s, where this guy, poor, uneducated, and he was charged in a federal court with breaking and entering into a pool hall and stealing some money and some liquor, and he demanded to have an attorney represent him. He was poor, he couldn't hire his own, he was incompetent to represent himself effectively, and he lost. The state judge says, I cannot appoint you an attorney. You have no right to an attorney in the state of Florida. And and Gideon, having read the Constitution, but not being necessarily sophisticated enough to understand it didn't apply to state action, insisted that he had a Fifth Amendment right. So he literally did a handwritten petition to the United States Supreme Court in the 1960s saying that the Sixth Amendment should be applicable to states as well, because no one can get a fundamentally fair trial without the right to have an attorney either hired if they can afford it, or if they can't afford it, to be appointed by the government to make it a fundamentally just system of convictions and acquittals. And he won. And that's called, the famous book was written by Anthony Lewis, guy right here from Massachusetts, called Gideon's Trumpet, came out of that. And a famous movie was made. It was such a big deal in the 1960s. The concept of the basically fundamental criminal procedural rules being applicable to state action. It was newsworthy, and there were special, little mini docu-series made in different news channels, CBS, ABC, and NBC, the big three back then. But they actually made a movie with the famous Henry Fonda. Henry Fonda starred in the movie from the book written by Anthony Lewis, called Gideon's Trumpet, giving all defendants where there's a risk of losing liberty, freedom, um, the right to have an appointed attorney, whether you can afford one or not. And so that's the process of incorporation through the 14th Amendment, made the inherent rights and civil liberties available through the Bill of Rights to be applicable to the state. The book's, I think, a little disorganized. When I'm talking about selective incorporation, and the first thing it really jumps to is the Fourth Amendment, which is to be free from unreasonable searches and seizures, and that if a warrant shall issue, it shall issue but upon probable cause, issued by a neutral detached magistrate. I used to have that memorized. It doesn't matter because we don't. I know this sounds terrible. It doesn't matter. It does matter, but it's a situation where what that actually means is derived from the courts. What is an unreasonable search and seizure? Does a warrant always have to be had by the law enforcement officers? And some of you already know intuitively, because it can't be every situation where someone is seized or someone is searched that a warrant has to be had, because there's exigent circumstances, emergency circumstances. For example, if a police officer sees me running out of a bank with bags of money and a mask on, and I'm running, and I got a handgun in my right hand, and I'm running down the street, they obviously have a right to seize me in that moment. They don't have an arrest warrant for me, but it's in the commission of the crime, and they've witnessed it, so they have a right to seize me. Now, if I'm acting suspiciously, for example, or just then they just arrested me, do they have a right to search my bag for in my person as a result of being arrested based upon probable cause for bank robbing? Of course. And the case law tells us when and under what circumstances you can be searched, your car can be searched, the trunk of your car. It's very, very context specific. So, and I'm not going to give you the specific answer because I don't always know unless I have the full context. And it's different in different states. So I'm just applying the Fourth Amendment to the United States Constitution, but you might get heightened degrees of protection under your own state constitution. We have something called our articles in Massachusetts, and that's the 14th article in Massachusetts is related to the Fourth Amendment to the United States Constitution. It actually gives us greater protections under the unreasonable searches and seizure standard in the federal Constitution does. So when I argue that the police violated my client's expectations of privacy and made an unreasonable search and seizure because they either lacked a warrant or probable cause or the exigent circumstances, I cite Article 14 of the Massachusetts Declaration of Rights along with the Fourth Amendment to the United States Constitution. But what's unreasonable? It's contextual. So sometimes when an officer might have a right to search you, your individual person, or your car in terms of the compartment area where you're driving versus the trunk of the car, the glove compartment of the car, or a briefcase in the car or a duffel bag that's locked in the car. All those create different standards of expectations of privacy, and the courts have created certain rules about when and under what circumstance a police officer could search those areas without a warrant. And we know there's major exceptions to those, like plain view. If I have on my seat of the passenger seat a gun, a shotgun, laying across the seat, and an officer just walking down the street, walking the sidewalk, can look in my car and see that there's a shotgun in there and it's not appropriately locked or secured, that officer has a right to seize that gun because the evidence is in plain view. It's the plain view exception. There's always consent searches too, and I'm always surprised how many people give consent searches. I've had clients that admitted it to me. They get pulled over legitimately for a bad tail light or something, or speeding, and an officer says, "Do you mind if I look through your car?" And sometimes even on the body camera videos, I'm surprised how the defendant goes, "Oh, I have no problem at all. Please search." And then they search, they find illegal items, whether it's guns or drugs or evidence of other illegality. And I'm stunned. And the question is it really consensual? Is it really voluntary under the circumstances when a police officer pulls you over and maybe there's 3 or 4 cruisers surrounding the car and there's flashlights in your eyes? Do you really feel like you're free to say no? But let's assume the person's warned, well, you don't have to give me consent. They sign a form, they sign a consent form, things like that. That's another exception to the expectation of privacy. You don't have an expectation of privacy and therefore no Fourth Amendment rights when you basically give consent to someone to search your motor vehicle or your person or your home or anything else. I'm always, even at home, cops come to the door and go, hey, we hear there's so many problems in your home. No, not at all. Do you mind if we take a look around? People say, sure, come on in. They come in and they find somebody that's been beaten up, or they find, well, back when marijuana was bad enough, and find pot plants growing in some back room under a heat lamp or whatever, however you grow those kind of plants, and they get caught right. Well, they had a right to be there and they observed things out in the open, so it was both a consent and a plain view exception to the Fourth Amendment. I have to admit, I win a significant portion of the cases that I win. I don't win that many, but what I do win is often on getting the evidence thrown out, because the court, both federal and state, created this principle that if evidence is seized in violation of the Fourth Amendment or Article 14 of the Massachusetts Declaration of Rights, the remedy is basically to not allow the government to use evidence that's been tainted by the illegality of the police officer's conduct. The federal rule has been etched away quite a bit because there's so many good faith exceptions under the federal standard that you almost have to prove now that the officer acted with malice towards a defendant's right to be free from unreasonable search and seizures, but not under the state of Massachusetts Constitution. There's still a pretty high standard that even if the officer acts in good faith, if they violated the principles of unreasonable searches and seizures under the Article 14, the evidence will be thrown out. And that doesn't mean the defendant wasn't guilty, so that upsets a lot of people. They say, well, the only reason the defendant's getting away is it's not because he or she is not guilty, it's because the technicality of having the evidence thrown out. But the argument on the other side that I'd like to make known is that, do we really want law enforcement to be breaking the law, the Fourth Amendment to the United States Constitution, the expectations of privacy in a free society, while enforcing the law? We want to have the same standard for everyone. So the only remedy right now that's really, I think, practical and that works well is an exclusion rule, because cops get educated and they do a better job developing probable cause, knowing when to get a warrant, knowing when to be clear about when and how far they can search or do further investigation to develop that next stage of probable cause that might give them the right to arrest and might give them the right to search without a warrant. People sometimes argue when they're first in one of my classes, well, they always have to have a warrant. I say, well, really think about it. You're a police officer and you're on the beat, you're in Gardner, Mass, you're doing a foot patrol, and you hear a woman screaming out of her apartment on the third floor. Oh my God, help me, he's stabbing me, he's killing me. And the officer looks up and he sees a woman looks like an immediate peril. She's hanging out the window and she sees a silhouette of someone looks like they're stabbing at her. Does that person have to say, I'll be right back, I have to go get a warrant, I got to call the judge that's on call right now and see if I have enough evidence based upon that to go in and search and to seize and potentially arrest and observe and gather evidence? No, it's an exigent circumstance. Or the other one I like to use is I see a bank robbery. I'm a police officer and I get the call at the station that there's a bank robbery at the Athol Savings Bank. I run down there and I see somebody in a mask running out with a rifle in one hand or a shotgun in one hand and a bag of money in the other, and they're running from the bank, and all the bank teller goes, it's him, he just robbed the bank, and I'm chasing him on foot, and he runs into his house, and I'm on foot and I'm in hot pursuit. I have to stop and say, I gotta come back and get a warrant. No, there's the Constitution is not a suicide compact, so there's reasonable exceptions to the warrant requirement in these different kinds of cases. And I don't always know when they are. It's very, very contextual. I have a case pending right now dealing with the search of a person who had things hidden on their person, but under their clothing, and it wasn't subject to any kind of noticeable observation from outside, just visual appearance. The question is, does the officer have a right to do that without a warrant? And so those kinds of questions come up all the time. The exclusionary rule is very controversial. I don't want to say it's dead, but it's definitely very anemic on the federal level right now. But again, most cases are state, and if you're in the state of Massachusetts, the exclusionary rule is fairly healthy if you're thinking as a criminal defense attorney. But even as a prosecutor, you want to know, do I need to ensure that my evidence has integrity? And oftentimes we're not fighting, which sounds a little bit jaded, but we're not always fighting about whether the defendant is guilty or not guilty. We're often fighting about whether they're going to be able to get an evidence that tends to prove someone's guilt because of the lack of integrity in evidence, because of how it was garnered or gathered by the police. So now when an officer can arrest and things like that, when can they get a warrant? It's based upon probable cause. That's that there's enough evidence that a reasonable, prudent person hearing the evidence and observing that if there's documentation or physical evidence would believe it's reasonable to conclude that a criminal act or evidence of criminal behavior is found at a certain location. That's probable cause. Again, it's a bit of a, it's a term of art, and you kind of know it when you see it, and that's what judges do. They hear that evidence from a police officer, and that judge or a clerk magistrate will determine whether there's enough evidence to issue either an arrest warrant or a search warrant. And again, you don't always need an arrest warrant. If an officer sees the event of criminality, they have a right to an arrest. And if it's a felony, if they have probable cause, they don't need a warrant to arrest under those circumstances. So, and the book does get into different expectations, whether it's a vehicle, the power to arrest. And that's what surprises people sometimes. Someone will be, there'd be plenty of evidence that somebody, stole some items from a store because they got caught on video. Maybe the security staff are reviewing the video later that night. And it was, oh, look, it's this person right here. They took the, $700 or $800 or thousands of dollars worth of jewelry from the store. We didn't catch them in the moment. We know who they are because for whatever reason, their ID was produced earlier in some way, or they just ID'd them from the camera recognition of the person, and the police are, that person is known to the police in that department. They can't go out and arrest that person, believe it or not. They actually have to apply for an arrest warrant and apply for an application for criminal complaint. Usually that's what happens first. They apply for an application for criminal complaint. They actually invite the defendant to come to a show cause hearing, and the clerk magistrate will determine whether there's sufficient evidence to issue the complaint against the defendant. And then there's an arrest warrant issued. Now the police can go and arrest the defendant. The statutes in every state give other authority to sometimes arrest prior to a criminal complaint issuing if there's probable cause to believe a criminal, because it's protection of like domestic violence. A cop comes to my door, we have a report, there's domestic violence. They don't witness it, they don't see it, and then my significant other says, yeah, Jim just punched me in the face. Well, it's after the fact. They do have probable cause, but in most circumstances, in a traditional case, they would have to go get an application for a criminal complaint before they could arrest me. But under those circumstances, Massachusetts has made an exception to the general rule that the power to arrest on domestic violence is only based upon probable cause without having to seek an arrest warrant. I know I'm getting very technical, but I just want the basic rule of thumb is we always have to examine. And if you're going to become a police officer, they have practice manuals, if you will, when and under what circumstances they can arrest somebody. Motor vehicles offenses are also different too, because the motor vehicle has mobility and so does the defendant. You get pulled over for driving with a suspended license and a suspended insurance policy and registration. They have the right to arrest, because if they don't arrest you, you're going to drive away with the vehicle. And there's just, the statute allows for that because the probable cause, and they've witnessed the criminality right in front of them. Once they pull you over, they identify the person. Well, they were driving, they had a suspended license, they had a suspended registration, and no insurance on the vehicle. They have the power to arrest. Those people will likely be released. I'll get to that in a second, what happens in arraignment. It's arrest. The book is a little different than an organization that would have done it. Oh, the Fifth Amendment, this is in double jeopardy. You might as well hit double jeopardy first, a little easier concept. No one can be tried to verdict in the same jurisdiction twice on the same set of charges stemming out of the same set of circumstances, facts. So the classic movie example is my client's been charged with murdering his partner. And he goes through the whole jury trial process, and he's found not guilty. And then he comes out later on the courthouse steps, or he tells his attorney, or he tells the world, yeah, I killed my partner, but I got away with it. I was found not guilty. Then people say, well, now they can charge him again and go after him because they got new evidence, his confession. No, you can't. Once that charge, murder in the first degree, stemming out of this fact pattern of his partner being murdered, has been tried to a verdict, you can't be tried a second time. Well, that doesn't mean the person now can't be charged with, perjury and obstruction of justice, and there's all kinds of other charges that often stem around the circumstances of a murder. So it would also, you could be sued civilly for wrongful death. So very rarely do the movies portray that the fact that there's usually often huge ramifications when someone's found not guilty and then later admits their culpability after the fact, perjury, all kinds of things. But generally speaking, think about it, it's a law that the colonists really wanted to put into all time immemorial, because the colonists that were in rebellion would be charged with all kinds of trumped up charges. They would have a jury, they would be found not guilty, and then the British government would just come around and recharge them with the same exact set of facts and circumstances from the same date and time, and you do it all over again. It's like playing a baseball game. You win, and then the other side says, nope, we're going to make you play it again. Well, we won. Doesn't matter. And same with if you lose. No, it doesn't matter. We're going to keep doing it again until we're satisfied with the outcome. That used to create a lot of rankle, if you will, in the revolutionary period. So you can't be tried twice for the same criminal offense in the same jurisdiction. That's called double jeopardy. Now, the one that's more important is self-incrimination. And I still get clients that call me up about this all the time. And this is where Miranda comes in. Miranda's a case. Miranda v. Arizona, also in the 1960s, comes out. And basically, it says when anybody is in a custodial situation, basically being under arrest, doesn't always mean you have handcuffs on you. Being under arrest is being under the apprehension of not being free to leave in light of the nature of the police officer's behavior around it. So if there's 5 police officers around me, and I'll get their flashlights on me, and a wall of a building's behind me, and they're all standing there, very intimidating. Am I really free to leave? I'm probably in a custodial situation, even though there's no handcuffs on me, even though they may say repeatedly on their the recordings, because now that many of them have chest recorders and that audio and video are taped, body cams, and they'll say, you're free to go, you're free to go. Are you? I mean, just words alone aren't enough. But generally speaking, the principle is if we can establish a person is not free to leave, they're in a form of custodial seizure. And as a result of that, if the police ask any questions of the defendant, the answers to those questions can't be used in a court of law because they weren't warned that they had a right to remain silent. They weren't warned that they had a right to an attorney. They weren't warned that they had a right to an attorney at all stages of the process, because it creates a huge disadvantage if you don't know your rights and if you're not warned of them. And most people don't. And Miranda is really a recognition that our society doesn't know their basic civic rights. And so in order to protect the integrity of our criminal justice system, when people are arrested, before the police question, which we call interrogation. Interrogation sounds like it's it can be really hard and threatening and intimidating. It can be, but all we mean by interrogation means being questioned. So sometimes you'll have a client, they get arrested, and they're brought down to the station for the official booking process. And when they're brought down there, they say that, I was never read my Miranda rights. I want the case dismissed. Well, I say, you were never asked any questions. You never made any statements that are going to be used against you. So it's totally irrelevant. So it's good that all law enforcement read and acknowledge the Miranda rights contained therein, so defendants know that they have certain fundamental rights that they can invoke during the course of the booking process. But at the same time, it's only germane, it only really has any meaning, is if the defendant basically said incriminating things regarding the case while in custody and while being questioned. So let's assume the Officer Smith, arrests Mr. Jones. He brings him to the station. It was a very hot pursuit thing. Everyone's all amped up over this long foot race, and maybe there was a scuffle at the end of it. And Officer Smith is very, very agitated and hyped up over it. And so is Defendant Jones. They get down to the booking room. Officer Smith never says anything to Mr. Jones other than stand right there. I've got to get the camera set up and I have to get all the forms out for you to sign. And then Mr. Jones, I probably already flipped the names. Mr. Jones says, yeah, you know why I killed that guy? Because he had it coming. He was a real jerk and he was really on my nerves and I had enough of him and that's why I killed him. Can that statement be used against the defendant? Because arguably he's in a custodial situation. He's handcuffed by Officer Smith. Keep getting the names flipped. And he made a statement that it certainly incriminates him. However, what didn't happen there? Officer Smith never questioned Defendant Jones, and therefore it wasn't prompted by an interrogation. So therefore the Fifth Amendment privilege against self-incrimination is not applicable. People are free to speak, and if they speak, it'll be used against them. But good police work dictates that during the booking process, it's often videotaped and audio taped. But even if it's not, it just brings a lot of integrity to a law enforcement's entity. If not only do they have the habit of reading verbatim from the Miranda card, they all have Miranda cards, they carry them with them, so you don't get any of the rights wrong or leave any gaps out. but also have it in written form with large, you know, 14 or 16 point font so that it's very readable, have it in multiple languages, and then have the defendant sign that they read those rights, that they understood them, and only then that they decided to speak to the police officer. With regard to any kind of question that might occur. But the Fifth Amendment's a big deal. I've had many statements thrown out because the officers didn't read or didn't have proof that they informed the defendant of their right to remain silent, and the information that they got out of the defendant in terms of talking to him or her was based upon questioning. So it's just good police practice, and that's what they teach the officers at the academy, to make sure you read these rights and have it on video, have it on audio, and have it written down and signed by the defendant. And they don't have to speak, though. They can remain silent. I'm not speaking to you. I'm saying a word. And that can't be used against him. You can't say, ladies and gentlemen, jury, when we brought this defendant into the Gardner Police Department, they refused to talk to us because that looks bad. It's very prejudicial. You can't even mention that. And I think rightly so. That's self-incrimination. That's double jeopardy. And by the way, just out of curiosity, maybe not curiosity, but a confession alone can't be used to convict a defendant. You need corroborating evidence because there's been a long history and a fair degree of evidentiary proof that confessions are often inaccurate, untruthful, or coerced through all kinds of different means. And so for a person to be convicted in Massachusetts, at least, you need more than just a confession. You need corroborating evidence to help bolster the proof that the defendant, in fact, did the act, not just the confession alone. Because we know there's a lot of evidence that people often confess to crimes for a number of reasons. Promises for leniency, trying to basically get a loved one out of trouble. Well, I can't comment on the case I have right now, but I have something along those lines right now where one person appears to be trying to take responsibility for an act they clearly did not do to protect a loved one who probably did do the wrongdoing. And so that's why we don't want to take confessions alone, to make sure we have the integrity in the law enforcement system. Often there's plenty of evidence outside the confession, but so they say, I got a confession. Well, it's great. That's one piece of the puzzle, but it's not necessarily the end of the case, just having a confession. I always think that, I think it's JonBenet Ramsey, this little girl that was in those pageants. She was murdered. They were looking for different, all kinds of suspects were involved, but some guy out in, an American, but he was out in somewhere in Southeast Asia, I think, as a teacher or some kind of, he was doing some kind of career out there. And he contacted, I think it was the Colorado District Attorney's Office with this full-blown confession that he did it. And they went out and flew out there, had him extradited, brought him back to Colorado, and then they did DNA testing, and it turned out that it was impossible for because I guess they have DNA evidence of whoever did it or something to that effect. It was impossible for him to have been the culprit in that case. So he was just confessing out of probably some mental illness or something like that. And he probably even convinced himself he did in fact do it. And then there's other evidence that turned out he wasn't even in the area at the time. He was actually in Southeast Asia when it happened. People confess to strange things happen. So confessions alone lack integrity in the criminal justice system standing on their own. Now the Sixth Amendment, it is just chock full of rights. And one is a speedy and impartial jury. Be careful here, although there were some things in the Federalist Papers that do give some credence to this concept of being tried by your peers. Well, if you're being tried by your peers, that means it's going to be somebody of the same age, sex, sexual orientation, maybe political identity, age, religion. We're not entitled to a jury trial by our peers because then it'd be almost impossible to get, people like you all the time to send a jury. What you are entitled to is an impartial jury, and that's the voir dire process. Don't ask me how to spell VOIRDIRE, voir dire. It's a French term, and it means to speak the truth. Let's make sure we have a jury that's impartial, is going to basically make their verdict based upon the evidence and the evidence alone. And that voir dire process that we do in court is basically when the jurors come in, we ask, the judge does it, but the attorneys can ask some questions as well too, just to make sure they don't have some inherent bias with the nature of the charges, the people involved. I do a lot of OUI cases, sometimes called drunk driving cases. And, and I always ask people, have you or anybody in your family ever been the victim of a drunk driver, either having lost property damages to a car, to your home or your yard, or have anybody in your family ever been hurt by somebody by a drunk driver? And just as important, have you or anybody in your family have been charged with drunk driving, because I think it makes them not necessarily in your favor either. It can go either way. So I think we want somebody that doesn't have the taint of, maybe they're activists, maybe they're involved in the MAD program, the Mothers Against Drunk Drivers, or SAD, I think it's Students Against Drunk Driving. All kinds of different things go into people's bias. Uh, that we want to ferret out, and we want a fair trial. And that takes a little while. That's why sometimes on a very significant case, like a murder case, the process goes very slow and sometimes can take days and days and days on really big sensational cases, because there's a lot of pretrial evidence. We don't want people to know about the case. They can know about it. A lot of people think, oh, they can't know anything about it. No, they can know about it. They just haven't prejudged it. They haven't drawn any conclusions about someone's guilt or innocence as a result of the stories they've heard. And I remember Michael Jackson, a long time ago, Michael Jackson was charged with, I think, some sex crimes out in California. It took months to get jurors on there that they all had heard stories about it in the news, but that seemed to be genuinely objective about what they've heard and hadn't come to any firm conclusion about either his guilt or his innocence in that case. He was acquitted of those cases, by the way. So that's the impartial jury. And the way we do it, we can excuse as many jurors as we can for cause. Like if I see that there's 50 jurors in a room, we're going to have a 6-person petite jury trial in the district court. They'll ask if you know any of the attorneys, do you know the defendant, do you know the witnesses, the police officer, and all those people stand up and be identified. And sometimes they'll raise their hand and go, yeah, I know Jim Corman. They're out because they know me. And it's not out of rudeness or that they're going to be unfair, but it's just fundamentally unfair to have somebody I know, whether it's a friend or a foe. They should not be on the jury trial. And outside of that, then it's that questioning process to make sure it's fundamentally fair. I don't want to spend forever on voir dire, but then we get two, depends on the system, but Massachusetts, the district court gives usually 2 peremptory challenges. These are called wild cards. Like sometimes I had a cop recently. I love cops. I get along very well with them, even though I'm a defense attorney, because I think I play fair ball, so to speak. I'm just I think I have integrity. So I get along with the police officers. But, I got a criminal defendant up there, and I think police officers are more likely to believe other police officers. So I asked that question. And guess what the police officer juror said? No, I'm not more likely to believe a police officer than a layperson. And he said it very credibly. It still wasn't a couple. So I have these 2 wild cards. They're called peremptory challenges. The only problem with a peremptory challenge is I'll use one. They'll kick off former police officer Joe Smith. I'll wave goodbye to him. But guess what? The next juror that come on might be more troublesome to me. I can't get rid of them because I can't cite a valid cause, and the judge does an inquiry, making sure they're fundamentally unbiased. But I just have a bad vibe. So you only use your 2 wild cards for that. And in the Superior Court, you often get more, sometimes 3 to 5 of these peremptory challenges. Be wise when you use them. Now, the right of confrontation, I think that's one of the most important rights in the 6th Amendment. You can't just come in and the cop says, well, I wasn't there. I didn't see what happened. But when I got there, Jane Doe told me that John Smith, hit her in the head with a baseball bat. That's hearsay. You have a right to actually that's not allowed in the court. And the reason why it's not allowed in the court, it basically defiles or circumvents the 6th Amendment right to confrontation. You should have the right to have the actual person that saw, heard, felt, experienced what it is you allegedly did or did not do, so you can cross-examine them as to their bias, as to their ability to perceive. And although I used to think I'd hate the movie, I swore I wouldn't watch it for probably 20 years. My cousin Vinny, and although parts of it were as silly as I thought it would be, where he's dressing in these ridiculous outfits in court, but some of it about just the ability of the defense attorney or the prosecutor to confront people that are going to give testimony and not be delivered third hand through somebody else. You can get into the fact, as corny it is, did you have your glasses on? Oh, geez, they look like they're wearing binoculars. Did you have? Oh, no, I wasn't wearing them at that moment, but I saw it, or, sometimes I've had people tell me that, not me, but I've had cases where I say, yeah, outside my window, I could see it. Then you go to the site and you look and it goes, well, geez, they could see part of it, but where they're saying it happens actually kind of around the corner. They can't see it. Maybe they heard some of the things, but they couldn't actually see it. And then you question what's saying. This isn't true. You actually couldn't see that part of the event because it went around the corner. And usually they're honest. Yeah, that's true. I didn't see it, but I knew what happened. That makes a big difference. The right to confront people occasionally. It's not like no one even knows who Perry Mason is anymore. But there used to be this TV show where this attorney would would have a case where it seemed hopeless, he's going to lose no matter what. But through the process of questioning the witnesses, they would all cave in and they would collapse and they admit they didn't see it or didn't do it, or they themselves were the culprit. It was real cornball stuff. Those things usually don't happen where people fall apart in the stand and admit they're completely lying. But do they sometimes admit that maybe their ability to perceive, maybe their motive, maybe their like or dislike of the people involved, maybe clouded some of their interpretation of the events they've seen? And even that, it's really remarkable. Sometimes you get police officers that are extremely gung-ho and they seem unreasonable in the way in which they perceive the different events. And I think that's very helpful to the defense. The other ones are often very hurtful to the defense. They're very reasonable. They don't seem overly strong in terms of their observations. They admit, like OUI, I get OUI a lot, and they almost always inevitably say, well, the defendant had glassy and bloodshot eyes. Well, that's an indication of consuming alcohol. So I ask the officer, goes, isn't it possible that my client had glassy and bloodshot eyes for a number of reasons? It might have been a natural condition of how his eyes looked. Isn't that fair? The officers that I think are tough to beat everyone goes, yeah, that's true. It could be. I don't like those officers. I want an officer who goes, no, it was because he was drinking and I know. Now that sounds unreasonable. But see how the power of cross-examination, the power of facing your accusers can really make the truth not seem as clear as what it did in the police report. That's why police reports aren't even admissible, because that's hearsay. The officer actually has testified as to what she heard. Victims of crimes have to say what they saw and experienced. One of the last trials, I was just telling my friend about a trial I had just before, it was quite a while ago, 2019, 2020. And it was pure conjecture. Basically, a store was missing some items, and they just decided to, that's how I interpret it, just decided to believe it was the third shift custodian that used to come into their building to vacuum and do things, because they had security cameras, and they saw that at one point the security film had stopped, and it was at a time when the store was closed and only the custodial staff was in there. And so later on, when they were losing or lost some merchandise, they just made through conjecture that it must have been the custodial staff that took it. Even though they didn't know how long the stuff was missing, they didn't have it in inventory, they didn't have receipts when they got it in, they didn't know when it left, they didn't know when it was stolen. And the merchandise itself wasn't even the visibility of the camera. So if the camera was on, you wouldn't have seen who took it anyways. It was just really, really a pure hunch. And we don't convict people on pure hunches, I hope. In that case, actually got what's called a directed verdict. I'll get to that in a second. The judge is there as a gatekeeper, and sometimes cases aren't even allowed to go to the jury because they're so fundamentally weak. And we want to have a judge to make sure an injustice doesn't happen that's so clear, and they're there to prevent a grave injustice like that. So the right of confrontation is huge. It becomes very controversial in sexual assault cases because a victim of a sexual assault is obviously already suffered a great deal, and now they're going to have to reveal their story in public. It's a public trial, and it has to be in an open forum, and they're often questioned by a defense attorney who is going to hopefully be a decent human being, but nonetheless challenge their perception, challenge their truthfulness, and challenge their story. And so there's an argument that sometimes victims of assaults and batteries, sexual assaults, rapes, and things like that are really punished almost by going forward. But imagine if you're the defendant being charged with one of those very heinous crimes. You'd want that ability to say, say if you believe, your client genuinely believes it was either consensual or it didn't happen, or it's a lie to damage because there's a fight over child custody. Who knows what it is? But the point is, the right of confrontation can't be waived. It's a Sixth Amendment right, and we've tried to work around it many, many different ways to avoid making people basically be a victim a second time. I'm not sure quite how you do it, other than hopefully to teach basic decent human decency and how you ask questions as a defense attorney. The speedy trial is another one too. You don't want to keep people held up. Justice delayed is justice denied. There's the statutes both on the federal and state level to help ensure what a speedy trial is. They're most important if the defendant is held during the pendency of the trial. If they have their liberty, there's still a right to a speedy trial, but there's not as much lost if there's delays in the processing. And it's got to be public. And why public? Although the public often doesn't attend these things, that way there's no shenanigans. There's no, if it's so fundamentally unfair, the press will get a hold of it and see that it was a railroad job, either for or against one side, and to be able to have public review of how the process occurred, um, you know, places light on it, and light tends to cleanse, the dangers of secret judicial proceedings. The right to counsel, that's Gideon B. Wainwright. Anybody who is going to potentially face a jail sentence has a right to a counsel, hopefully a pretty decent one. And they're appointed at a sliding scale. You don't have to pay anything if you're very, very poor. And if you have a modest amount of income, there's a sliding scale. And then the Eighth Amendment right to reasonable bail. Bail is not designed to basically pre-trial punish people for crimes. It's to make sure they're going to return to court. I had a bail hearing this morning. My client was from Worcester. All of his ties are in Worcester, grew up in Worcester, graduated from Worcester High School, always worked in Worcester, never lived in any other physical presence in his 28 years other than Worcester. He has a long criminal record for a fairly young person, but he always showed up to court. And the current case he has was fairly minor. And those are the kinds of analyses the court has to go into to determine whether or not this person is likely to appear before court. And if they're not likely to appear, what amount of money would help ensure and motivate that defendant to come to court? And that's bail. The more serious the offense, the higher the bail. And sometimes if they do something called a dangerousness hearing, if it looks like no terms of release can really protect the public from future violence, then the defendant can be held for a period of time based upon dangerousness. But bail is usually not related to dangerousness. Bail is just related to the likelihood of the defendant returning to court. This sometimes upsets people. Someone is clearly guilty of shoplifting, clearly guilty of hitting their significant other, and they go to court and they're released that day, and people are outraged because I can't believe it. This guy is clearly guilty. I can't believe he's not being punished today. Well, we only punish people after a verdict or after an admission of guilt and there's a verdict, not before. And that's one of the drawbacks of a free society. It can sometimes seem a little bit troubling to the victims of crime. And that's bail. I don't know. And the court tells us what is cruel and unusual punishment. I don't know, chopping your hand off for a larceny might be clearly cruel and unusual. I don't know what the standard is. The death penalty, certainly not. And I'm an anti-death penalty guy. I mean, I'm not a fervent, advocate about this, but I'm opposed to the death penalty. But do I believe it's a violation of the Eighth Amendment? No, because at the time the Eighth Amendment was adopted, the death penalty was, pun intended, alive and well in the United States. So the death penalty is a constitutional mechanism to have in our judicial system. I don't like it, but I'm not the law and I'm not in the Supreme Court. And even if I was, I would probably say it's not cruel and unusual punishment for the most egregious offenses. Why? Because it was adopted during and clearly in the recognition that the death penalty be appropriate for certain offenses. Now, how about the death penalty for jaywalking? Well, now it becomes cruel and unusual in light of the nature of the offense done. And that would be a cruel and unusual. So it's not always just nature of the punishment, it's vis-a-vis what the crime is. And I don't always know what they are. Castration, chopping out, gouging out people's eyes, drawn and quartered. There's obviously different degradations of the kinds of different things we can look at contextually, but it's up to the courts to tell us what is in fact cruel and unusual punishment. I think we're going to process now. What happens after you get arrested and charged? Yeah, stage of the criminal offense. Well, now, once there is a valid criminal complaint brought, whether it's through the application of a criminal complaint where the officers didn't have a right to arrest, or after an arrest and a defendant is brought to court, there is an arraignment process. In that arraignment, the defendant is asked whether they're going to plead guilty or not guilty. And this surprised a lot of people. The defendant will say, I always feel, I shouldn't feel bad for them, they're guilty, but someone goes out and drinks too much at a company party, they get arrested, they get charged, cop found them swerving on the road, thank God no one got hurt, they get charged with OUI, they're held overnight because none of the courts are open, they come into court the next day, and boy, do they feel bad, not only because they have a terrible hangover, but they've been charged with a fairly serious crime. OUIs are fairly serious, there's going to be huge ramifications as losses of license and fines and driver alcohol education programs, and that's providing that they have no other criminal offenses in their history. Now, sometimes you'll see somebody come in and you can tell they just feel a great deal of remorse, they feel bad, and the judge will say, "You've been charged with operating under the influence of intoxicating liquors in the Massachusetts under Chapter 90, 24D. How do you plead?" And the defendant will say, "Guilty, Your Honor." And the judge will say, "I'm going to enter a not guilty plea on your behalf, and we're going to schedule this case for a pretrial conference." And the defendant goes, "Judge, with all due respect, I think you misheard me. I want to plead guilty." Sometimes judges don't want people in the heat of the moment that are not attorneys, or even attorneys, but that are not being represented at that moment, attorneys with clarity, to plead guilty because they don't always know the nature of the offenses, the elements involved, whether they've been overcharged or whether there might be potential defenses to the case. And so they often won't entertain a guilty verdict at arraignment. And that's what sometimes confuses people when they go to court and say, "Hey, that guy just didn't want to be guilty," and the judge won't take it because they want time for reflection, time to cool off, time to, whether alone or with an attorney, to really evaluate the nature and strengths of the charges against the defendant to determine whether they should muster a defense or maybe work out the disposition to be as favorable and appropriate for the defendant as possible. An advocate to do that can help them with that, or they can do it on their own. So that's the process of arraignment. First, the defendant's formally told what the nature of charges are, that how else can you defend yourself in a free society? You need to know who your accusers are, what you're specifically charged with. And then there's a question of whether or not you should be held or should you have to post some kind of bail before you return to court. The court also asks whether you're going to hire an attorney, represent yourself, or ask for a court-appointed attorney at that stage. You can change your mind during the process. You're always free to hire an attorney, even if there's no jail time potentially there for you. And you're always free to represent yourself. And there's an old saying, anybody that represents themselves has a fool for a client. Even attorneys shouldn't represent themselves because sometimes it's hard, you get too myopic and you focus on one little aspect of the case, and it's hard to see the whole global picture. You should always, I think, be represented by counsel if you take the case seriously. So that's the search. I don't know all the search stuff. Grand jury arrest, the preliminary hearing, bail, interrogation, arraignment. After the arraignment, they're given another date, and sometimes there's, as a condition of release, it's the form of bail. You don't have to post any money, but you might be ordered to stay away from an alleged victim, to stay away from a store that you allegedly caused a ruckus in or did some shoplifting, things of that nature. And sometimes the court will do some interceding in a defendant's life. If they think the person has a very serious alcohol or drug problem, they might say that they're to stay alcohol and drug free during the pendency of the case, and they're to check in with probation for doing random urine screens during the pendency of the case. And the court does have that power if the nature of the offense is related to that, and they make a determination that that's an issue. It's not always about punishment. There's a rehabilitative process, I think, that the court tries to get involved in. And then we go to the different stages. There's a lot of pretrial hearings. Sometimes you'll do a motion to dismiss because there's simply not enough evidence that the Commonwealth has submitted to even ask for an application for criminal complaint. So you try to nip it in the bud with a motion to dismiss. Then there's motions to suppress, arguing that the evidence seized or the confessions made or illegally attained. And then you go through the pretrial conferences and you exchange information. We don't want trial by ambush. We don't want a surprise trial. Who's got evidence? Who's got witnesses? All that stuff has to be disclosed by both sides prior to trial because we want to be able to resolve cases one short of trial, and it helps resolution. If I know what all the other side's evidence is, they know what all my evidence is, reasonable minds can look at it and evaluate it, and then maybe a disposition can be worked out based upon knowing what's likely to be presented to a reasonable juror or judge, because you don't have to have a jury trial. You can waive it if you're a defendant and have a judge trial. And we do that based upon which judge comes out that day. And we sometimes think like, jurors are really a stranger to us. We know very little about them. But I might know this judge from the past 20 years, and I think he or she is just a really good judge, and they do things very right and very fair, and you'll get a just trial in front of them, and it might take some of the intimidation of it. So that's a jury waived or a bench trial versus a jury trial. But when we get to the jury trial, all that information takes months and months and months before you get to that jury trial stage or a judge trial, again, depending on what you elect as a defendant with the help and counsel of your attorney. But at trial, what happens? It's the government's burden. The government has to prove the case, and it's by a very, very high standard, and it's proof beyond a reasonable doubt. In Massachusetts, that's defined as the jury has to have an abiding conviction to a moral certitude that the defendant did the acts as alleged based upon the evidence they submit, not on their argument, not on what they think they can prove. They're going to prove it through testimony, for physical evidence, through documents, and they have to be able to muster the credibility standard to be admitted to evidence to show validity. And the judge is the gatekeeper to determine whether or not that evidence has merit and validity and foundation before it can be produced to a jury. And that's the process. It's an adversarial process. So the prosecutor goes first, does an opening statement, then a defendant makes an opening statement saying why the evidence that's about to be presented won't equal proof beyond a reasonable doubt. And then they start calling witnesses, and then the defense gets to cross-examine and probe and challenge. And then when the government's done, the defense almost always privately, not in the earshot of the jury, asks for what's called the required finding of not guilty, saying the Commonwealth simply hasn't met its standard as a matter of law. It's a way to weed out an exceptionally weak case. It's also called the directed verdict in some systems. So if that doesn't prevail, now the defendant is asked whether or not they want to put a case on. And the defendant doesn't have to. Defendant's under no obligation to do anything. They have nothing to prove. It's entirely the government that has to prove their case beyond a reasonable doubt. The defendant is presumed innocent, and that presumption never shifts. It always stays with the defendant until and if the government can prove beyond a reasonable doubt. Reasonable doubt's hard to define, but it's kind of easily understood. It's just a very, very high degree of proof. And again, Massachusetts has that funky definition, which I think is beautiful, but how do you really understand it? You have to have an abiding conviction to a moral certitude that the defendant did the act. Mere probability alone, even a strong probability, is not enough. You must be convinced to a moral certainty. Sounds nice, but I think jurors just do whatever they feel is appropriate. Do they believe the defendant did it or didn't do it based upon life experiences? I think Black Law, I used to have Black Law's dictionary memorized, that whole thing, just on proof beyond a reasonable doubt. I like their definition. It's that degree of proof that leaves you without hesitation to draw a conclusion based upon the evidence you've heard. Yeah, it's kind of like, I'm very confident the defendant's guilty. But the thing is like, this is a human experience, and I think jurors do it practically is there. But when I do a closing argument, so after all the evidence is in, the defense goes first in the closing argument, and I really push. And I said, ladies and gentlemen, jury, even a strong probability, so you got to have an abiding. And I always call the other side, not the Commonwealth or the district attorney. I always call them the government, because no one likes the government. And I said, that's your civic responsibility. Return a verdict of not guilty if you don't have that degree of certainty. And then I'll talk about where there's weaknesses in the government's case, and then the prosecution will rally and do their closing argument last, arguing why, based upon common sense and reasonable inferences from all the evidence put in, that the defendant is in fact guilty beyond a reasonable doubt. Then the judge charges the jury, tells the jury what proof beyond a reasonable doubt means, what the elements of the crime that the defendant's been actually charged with, what the government must prove, each and every element beyond a reasonable doubt. And then the jury goes and deliberates. And what's interesting about that is, in the criminal session, it's got to be unanimous. It always was unanimous on the federal system. I think it was always unanimous in Massachusetts, but up until recently, there were some states that only required like a supermajority of the jurors to convict. That has been recently resolved by the United States Supreme Court out of the case out of Louisiana. Now, all criminal cases where defendant risk losing their liberty or autonomy, the defense is entitled to a unanimous verdict. Now, careful, the verdict is either guilty or not guilty. Don't say guilty or innocent, because many times the jury's, I think they did it, but I'm just not that convinced, and I'm trying to do my civic duty, but I still think the defendant is probably guilty. A friend of mine just had a jury trial recently. It was a very serious gun case, and he won, and he said, he goes, wow, this is great. And he goes, man, I did a really crappy job, but the government did even a crappier job, so I think the jury was just not that confident in coming in with a guilty verdict. So when you're not confident, that's when a not guilty verdict should be had as a civic responsibility as a juror, because it's better to let the old saying, 100 guilty people go free than one innocent person should lose their liberty. So that's why we have this very high threshold of proof required before we have a defendant get convicted. Now, after that, that's the verdict. Or the jury goes and they deliberate very privately. There's no intercession. We can't hear what they're saying or anything. They go as long as they want, but at some point the judge will ask them, hey, where's the verdict? And sometimes they become deadlocked. They can't come to unanimous verdict. If they can't come to unanimous verdict and too much time has gone by, a judge will declare that it's a hung jury. They can't come to a decision. The case is then what? It's a mistrial. They dismiss the case. The government's free to bring it back in. Hey, what about double jeopardy? Double jeopardy applies only if there's been a verdict. A hung jury is not a verdict. They can retry the case. If it's a small, if it's not the biggest case in the world, sometimes they'll just dismiss the case and not retry the defendant. But they'll often go after a defendant multiple times until they get a verdict one way or the other. Once there's a verdict, the case is over. Let's assume the jury comes back. They give a verdict. They read it. And then the judge determines the punishment within the bounds of what the statute gives. Sometimes the judge has a lot of discretion, 0 to 5 years. It could be probation, or it can be up to 5 years incarcerated, or it can be a very, very narrow where the judge basically, this is what you get. If you're, like first degree murder, there's no latitude for a judge. First degree murder requires just one sentence and one sentence only, and that is imprisonment in the state prison for life without parole. So there's not really a big role after a jury finds a defendant guilty of first degree murder. But other charges have a lot of latitude, and then we do a sentencing, sometimes that same day, but other times they do a sentencing hearing in front of the judge where if you're a defense attorney, you make arguments why your client deserves, the most lenient of sentences under the parameters provided in the statute, because maybe other good things they've done with their lives, or haven't been in trouble before, or health concerns, all the different mitigating circumstances. And the prosecutor will ask there. Sometimes they're in agreement. Sometimes the prosecutor and defense, this is a first-time offense. The defendant's not the biggest jerk in the world. You don't say it quite like that, but you get my point. And we think, the minimum mandatory be appropriate. And sometimes the prosecutor will go right along with that. And the judge doesn't have to agree with that either. So that's what's sometimes very shocking. I feel good that I got the prosecution and we had a brief recess and we discussed it. We have a joint recommendation for the court for sentencing. You get a judge say, well, that's wonderful, fellas, but I'm not doing it. I'm going to go over your heads and, impose a much stiffer sentence. Now you can appeal not only the sentence, which is rare, but you can actually go to a sentencing appeal. But most of the times, if you're going to appeal, it's not based upon, I can't believe the jury thought I did it. You have to appeal based upon an alleged error of law, that something in the process or in the way the evidence was admitted or denied, or the conduct of the trial was flawed. But you don't challenge the factual conclusions of a jury. That's otherwise every single case would be appealed. Got to find an error of law. And that's why it's important for the governor to appoint very good judges, and judges to become very astute at making sure they do a good job and making sure the trial was conducted fairly. So that way the verdict, whatever it is, tends to have validity, and the appeal will be very, very unlikely in terms of success. But you always have a right to appeal. But you got to, again, what do you have to do? You've got to cite an error of law. Well, that was a very, very long video. I thought I was going to do it in about 20 minutes, but this is my bailiwick. I love criminal procedure and law. There's a lot to know. It's got its own course, but I thought it was worth going the distance on this one, and I left a lot of gaps. Any questions, any concerns? Don't ever be afraid to reach out and ask for some input.